purported publication of final panel list of candidates. Post of the petitioner has also not been made aware with regard to the aforesaid final list of candidates.
Same.
Identical
Same
order, দেখে নিন।
Same society.
I am representing penal. I am state.
See, he is appearing for 3.
I am state law.
Oh, only 2 করে দিতে।
Why am I? I am also state.
Provision service. First minute.
I am only state.
Let them come, Mr. Nayak. Let us see. See, the nature of allegations are serious.
But what statement is saying that
I don't know. He has not said so.
It has
Now let them come. Let the society come forward. I've said secretary also. I've directly secretary also. Let us see if on the next date. If they do not appear on the next date, I will direct you to take steps.
The manager is there.
no, I speak employee here manager.
So?
Whatever is not there, then I speak employee.
Yes.
They made a party. Then it will be effective.
It has happened.
Anyway, let us see what happens on the returnable date. Next.
No, I am not declared.
Call the next matter.
I am only state.
2 হবে শুধু 2 হবে।
We are not saying
সব করে 2 হবে না। 6 এরটা 6 হবে।
104.
আমাদের
আর দেখবে সেক্রেটারি একটা আছে। সেক্রেটারি একটা আছে, সেটা সেক্রেটারিটা বোধহয় 4 and 6 কে ডিরেক্ট করলাম আসার জন্য। আর মিস্টার নায়ক শুধু 2 এর হয়ে অ্যাপিয়ার করছে। And yes.
Actually, I am only state.
1104.
Application.
Page. Yes. Who's appearing?
Same matter, man. 1140.
Very well, same order. Yes. Open affidavit of service filed in court is taken on record. তারপরে next.
My lord, I beg to appear for the petitioner, my lord. My lord, in this matter, my lord, I am not briefed, my lord. The advocate on record is not here, my lord. I am kindly praying for some accommodation, my lord.
Since an accommodation has been sought for on behalf of the petitioner, let this matter go out of the list.
My lord, may it be taken up next month, my lord. After?
Ajay, let this matter appear in the monthly list of May.
Grateful, my lord.
Yes. Since an accommodation has been sought for on behalf of the petitioner, let this matter stand adjourned and appear in the monthly list of May. You are appearing in this matter? No. Yes, call the next matter.
I'm appearing for the petitioner, my lord.
Yes, yes.
I'm for the petitioner. My lord, here, affidavit of service. My lord, here, it's the petitioner, my lord, is a widow, a 70-year-old widow. What has happened is, my lord, the maintenance charges were used to be taken care of her by her husband. Husband had not paid the maintenance charges for the cooperative society from 2007 to 2022. After the husband passed away, she realized that the maintenance was not paid. So when she went to pay the maintenance, she realized that the society is charging interest at the rate of 18%, a penal interest at the rate of 18%. She has, as of date, paid the entire interest also. So the principal was 93,000 and interest was 2,89,000. She has paid 3,83,000. After that, she has made a representation for waiver of the interest or also to the society. Society did not agree. Then she also went to the consumer forum. Consumer forum said that this cannot be decided by the consumer forum. Then she's made a representation, not a complaint under 102, but two representations. My lord will see page 50, 21st February 2024, and subsequently again on 3rd June 2024, saying that this penal interest which is being charged by the society, that should not be charged, and the interest should be refunded, which has been taken by her. My lord, may I complete? So, my lord, the only issue is whether the penal interest at the rate of 18% should be charged or not. There is, my lord, the provisions of the bylaws of the society, my lord, Rule 49, which is at page 33, provides interest on due on arrears, which is not at 18%. It is much lesser. It is, my lord, if your lordship takes Rule 49 at page 33, a member in arrears after 30 days from date of demand shall pay interest at the rate of 1.5 paise per rupee per month on the amount outstanding. 1.5 paise per rupee.
That is very high. That is more
That is also high, but not 18%. That's what I'm told. I've not done the calculation
No.
myself.
You see, Mr.
Per
Mukherjee, how means 1.5% a month.
A month. It does not 18% per annum. Whether
Wait, sir. Let me understand. Then I'll come back to you on this.
so, this is there in the act. I am,
Where is it? 1.5 paise?
my lord, if your lordship, page 33, Rule 49. That's also very high. But I'm told that 18, whether it's 18%,
But
1.5%
this
per
is
annum.
the bylaw.
There's a bylaw. So, my lord, I have, in my representation, I have said that the bylaw is also contrary to the rules and the act. Because, my lord, 18% could not have been charged. Because no penal interest is provided under the rules and the bylaw, rules and the act and the rules, my lord, Cooperative Society Act and the rules. So, my challenge is, my lord, twofold. One is, my lord, the bylaws.
So you see, Mr.
Rule-
Mukherjee, then the society will find it very difficult to function. If the members stop making payment of today, maintenance is not paid by the members. And they say, no, there is no penalty interest. So I will pay it as per my desire. Not in this particular case, maybe other cases.
Yes, my lord.
So it will be very difficult for the society, especially a housing society, to function. This is an housing
It
society.
is a housing society.
Function.
Well, 18% possibly is too high. Well, at the regular rate of 8% or something is understandable, bank rate. But 18%, I have not, well, no society or even the maintenance which is there, no society or even today in all these DLF or these Arvana, all these societies, they
Yes.
also don't charge at 18%.
What is the general rate?
Around bank rate or something of that at the highest, not more than that.
Yes.
18% is too high.
What is your basis of charging 18%?
There is a bylaw saying that
Show me from the bylaws you are entitled.
any transport carry the rules 102.
I'm agreeing, my lord. I have not followed the
I
right
will take
procedure.
care of that. You tell me. That will come later on when I will decide the matter.
Bylaws is
You show me from the bylaws you are entitled to charge 18%.
Settle there for the bylaws with the for the gratuity.
Show me that you have not charged more than the bylaws. Show me.
Also, 102 rules there. Any dispute.
102, I'll not go. For the timing, you tell me what is the basis for fixing 18%. Just show me that.
Since 2007, there is a pending matter. There is a pending of cooperative society rate. There is a since 2007.
Rent
Maintenance charges,
maintenance.
maintenance charges.
or maintenance. No rent. Maintenance charges. And maintenance charges, according to them, has been cleared.
Whole
They
thing.
have paid the entire amount. The amount is not outstanding. They want,
Has paid the amount in the year of 2020.
along with interest,
2022.
whatever has been paid, your rate of interest, it has been paid. It is not that a person is coming to court and to resist payment of interest. He now wants a determination on this. You tell me, what is the basis of charging 18%?
There is a bylaws is there for the
Show me from the bylaws you are entitled to charge 18%. Calculate it and tell me. It is 1.5 paisa
1.5%.
per rupee
Yes,
per month. How much that comes to?
that is my lord.
18%.
18% lordship.
Are you sure?
Yes, lordship.
Not a paisa more, not a paisa less. No, no. I'll be very strict on that. You find out what is your calculation. Tell me. When you want to come back, tell me. And what was the original figure?
My lord, principal was 93,000 and interest was 2,89,000. I have paid total 3,83,000. The lordship,
Society
paragraph 12, I have said so. My lord.
constructed when?
My lord,
Formation
my
when?
lord, I became a owner in
No,
2001.
when was it constructed?
I do not know that, my lord. 2001, I became a owner.
On the death of your husband?
Death not. I was the owner of the flat. My husband had purchased in my name. From 2001, my husband passed away in 2019.
This bylaw is of 2000.
2000, possibly, my lord, around that time only, my lord, the property is. This is Santoshpur.
That is my lord. South Calcutta center.
Bylaws is registered in 2000.
Society is registered.
Society is registered in 2000, my lord.
Yes, I've seen this.
Society is registered in 2000. I don't know which year it was constructed, my lord. Should be around that time.
So property housing society, that is page 14.
You want to take instructions whether you all, because you see the entire amount has been paid now. Yeah, 1.5 paisa. 1.5 paisa. Yes, I've seen that. So yes. So one paisa, everything is calculated on rupee. So 1.5 paisa per rupee means it will be 1.5%. 1.5%. They didn't take instructions and come back.
That's it.
No,
No,
no, on
that-
this, on this only. What is the basis of his charging? I'm not asking him to consider it at this stage. Mm. I understand that. It is not because you see today, if such provisions are not there, then it will be very difficult. But there cannot be unjust enrichment also.
My
Correct.
lord, I have there's a judgment where, my lord, penal interest when it was being charged, the society was asked to amend the rules, amend the bylaws. Copy that. Only single them. Correct? Well, a penal rate was charged. Of course, well, this was after going to the registrar. Registrar had directed. Where penal rate was being charged, the registrar had directed bylaws to be amended so that penal rate is not charged. That was not done. Then the petitioner came to court, and finally, my lord, there was a direction from the court to change the bylaws immediately.
That is the another matter. This is not the matter.
Well, I'm relying on a different judgment in another matter.
No. Reasonable interest, something it is all right. Now, very difficult, very strict terms means you see, if you have ever read, Mr. Nayak, the credit card terms and conditions,
Yes,
you will find similar such terms and conditions are there. Similar such terms and conditions. But they are doing business. Society
can't be doing business.
cannot do business.
And cooperative principles, rule 3, section 3, all those have to be followed.
Very well, let him take
Let him
instructions
take
and come
instructions,
back
sir.
on the next date. I'll consider this.
Yes, my lord.
Correct, but that has to be in consonance with these other provisions, constitutional provisions. At the end of the day, nothing can be, notwithstanding it is a co-op. You see, it is not a simple contract between two persons. Not a simple contract. It is guided under the framework of Cooperative Societies Act.
But my lord, can you only formal clauses are there, or to the law structure of the law bylaws. Here we say that before the members, they will decide how to run the society.
But their decision cannot go counter to the constitutional provisions.
Not contrary to law. Anything cannot be done which is contrary to law.
But this is also apparently appearing 1.5 paisa per rupee is also apparently very high. Very, very, very high. So this, whether the registrar had applied his mind here is another question. Maybe the petitioner may not be getting benefit of seeking return of the entire amount, but for future. Correct. I will direct you to take decision in this regard, but later. But that is later. Yes, Mr.
I am only
Not profit making also. Can't be profit making also at the end of the day.
Go to the register. He has not gone to the register first. His observation
I'll
is
take
another
care of
matter.
that, sir. Sir, power is plenary, sir. Power is plenary, sir. If you want, I will decide it here and now. Power of the writ court to issue a writ is plenary.
No, that is correct. That is correct.
Constitutes, there is no restriction
But when
in exercise of such powers.
when
So in a fit case, the court is competent to issue. You see, it is a self-imposed restriction. The court does not proceed and interfere. But certain matters the court may. So you produce the
That is correct.
particular.
But-
It is not that the court does not have the power.
No, but when, my lord, I have not said so. But when
I
there is a
understand.
restriction-
So you take instructions having regard to the peculiar facts of the petitioner being charged. Opposition will come later. You come up, tell me. I'll issue directions if necessary. I may not entertain also ultimately. There are many things, sir. You come up with your instructions, show me. I might be interested to go through your records, especially your audited accounts. একবার দিয়ে দাও। The petitioner is also directed, the respondent numbers 3, 4, and 5 are also directed to produce the audited accounts of the said respondent for the assessment year.
Yes, sir.
Next.
I'm obliged, my lord. Affidavit of service is
Here, yes, it will be indicated. Next, call the next matter. Yes, Mr.
That I appear on behalf of respondents number 12 to 14.
Respondent number 10.
I appear on behalf of one of the intervening parties.
Where is the petitioner? Intervener will come later. Without the petitioner, I will not permit you to intervene and hijack the petitioner's case.
But Malad, I am only praying for addition of party, Malad. That can one is my
Yes,
application,
where is
Malad.
where is the petitioner? I'll dismiss the matter, so it will be better. Can one also gets infractures? Yes,
No, Malad, but my presence is very much required in the matter, Malad.
unless the petitioner
Allows the can one and Malad then dismisses it.
no.
Because I have only sought for the addition of the cooperative society as a party in the writ petition, Malad. Malad, they have made the manager a party of the writ petition, but they have not made the cooperative society a party to the writ
Who
petition.
will represent the cooperative society?
Malad, the manager.
Who will represent? Is
Malad,
the secretary is there?
Yes.
Secretary is there.
No, the secretary is not
And
in
the
the
manager is the only
arrangement of party.
person.
No, Malad, the secretary of the society is there. That is what I am beseeching your lordship. That is what I am submitting.
Since the petitioner is not represented in court, the writ petition is not being since the writ petition is not being considered.
In
Me. I do not know because of the heat, Mr. Bhattacharya, the gentleman may not be here. So I do not know because looking at the see the temperature, scorching temperature outside,
yes.
you
yes.
never know. So let it be there tomorrow in the next month. May. Yes. আরেকটা
Let it appear. Only one thing may I say. A matter may appear in the monthly list as a last chance.
No.
I leave it to my.
I don't.
I leave it to
Really,
my
I'm not
lords.
dismissing.
I have nothing to say. But kindly will appreciate on the next occasion.
Yes, sir. Your matter is there. It will take time. Sir, you are appearing in the matter. Next matter. You are appearing. 20. It will take time.
My lord, in the same matter, there is another another litigation is there in the cooperative tribunal. Actually, this writ petition was filed.
Then I'll
on
come after recess.
My lord, I don't want to proceed with this now because
Very
the
well.
tribunal is there.
Very well. Yes, Mr. Ghosh. What?
Appeal is pending against award pending. At that point,
At least from the civil code, you got some chance to come here. Yes, heard since the learned advocate for the petitioner would submit that he has instructions not to proceed with the instant writ petition, let the same be dismissed as not pressed. Yes, it is better now, sir.
My lord, my lord, one untimely mentioning, my lord, my daughter is admitted to the hospital. I have item number 1153.
So I'm not dismissing any matters. It will only go to the monthly list, next monthly list.
My lord,
I'm not dismissing any matters.
my lord, let it just be not this week. I'll keep someone, my lord, who will pay for time. 1153.
লিখে রেখে দাও।
That is the blessings of my lords. Why I say in the scorching heat, my lord is not dismissing a repetition. Scorching heat,
Absolutely, absolutely. It's very difficult. You see, Mr. Bhattacharya.
day,
Yes, yes, yes.
an extreme temperature has now come.
Yes, yes. All on a sudden, the temperature. That makes it more difficult, Mr.
আইটিআর চাইলাম যেটা ওখানে স্পষ্ট হয়ে যাবে।
ওগুলো এখানে নিতে পারবেন না পয়েন্ট, কিন্তু অ্যাপিলের এগেনস্ট রিটে আসছে না। তো এখানে স্কোপ তো সামান্য, তো ওরা করে ফেলে। এখানে ক্যালকুলেটেড ইলিগেলিটি that has happened, that is to be খালি point of consideration.
পয়েন্ট অফ ভিউ
My lord, I am for the petition. My lord, this is that matter, my lord, relates to, my lord, transfer fees. My lord, what has happened, my lord, in this case, my lord, the arbitral award was passed directing the society to refund back of rupees 5 lakhs, which has allegedly been received as a transfer fees. The stand of the society is there.
Respondent number 3, private respondent.
Private respondent, my lord, my learned friend is appearing. Well, everybody is appearing. Straight. Well, everybody is appearing. Now, my lord, first of all, my lord, I shall show to your lordships, my lord, the relevant provisions of under the Cooperative Societies Act first. My lord, what natural justice has been violated by the arbitrator as well as by the tribunal while deciding of the instant case, my lord. And none of the rule has been followed at the time of deciding of the arbitration as well as before the, my lord, tribunal, my lord. My lord, that's why before this application has been filed under Article 226 by the society, my lord. My lord, society has not accepted this amount as a transfer fees. First of all, my lord. My lord, we are for the society. The society has filed these applications, my lord. The Stadium View Cooperative Society, challenging the arbitral award, order passed by the tribunal, dated, my lord, 30th of April 2024, Cooperative Tribunal. Under the provisions of 166 of the rules, my lord, cooperative rules, it starts with chapter 9, 11, my lord. Reference of a dispute. First, my lord, dispute has to be before the register. বিলটা কোনটাতে? অ্যাপিল মাথা মামলা করবে। So it is a dispute raised before the register under section. But, my lord, so far the, my lord, the procedures are concerned, my lord, the entire civil procedure code has been followed in this case also, my lord, for recovery. No. No. This is an award. This is the award. Yes, 226, 227, yes. Yes.
conflict. Order can be accepted before but at the set aside of the other, allowed the order, above the order, but no other ancillary order can be had. The 226.
অ্যাপিলটা বার করো ওইটার থেকে। না না না, আপনি আপনি ওদিকে ছাড়ুন, সরে অ্যাপিল কোন প্রভিশন হয় বের করো আগে। এতদিন ধরে মামলা সব প্রশাসন স্টাইল বার করো।
হ্যাঁ, লেখা আছে।
Because this is one side. This is the academic
My lord, our initial days of practice.
Not there. Option for the Lord charging transfer fee. Operation department by
Look, that-
all this society.
That is on merit, my lord.
Charge transfer fee. And the government to the schedule not such a way to look at this section.
কি হচ্ছে? One 137. 131 টা কি দেখাচ্ছিল স্যার? না স্যার কি দেখাচ্ছিল স্যারের বইটা থেকে? স্যারের বইটা থেকে কি দেখাচ্ছিল এটা? কোনটা দেখাচ্ছিল? My lord. My lord, first, my lord, the arbitral, my lord, the award was passed in terms of 102 of the my lord cooperative society. My lord, my lord, my lord, my lord, my lord, yesterday your lordship had part of the my lord. No, no, it's my lord. My lord, so far 226 to 27. My lord, first of all, my lord, kindly consider the case. My lord, what is the case here, my lord? My lord, first of all, my lord, the private respondent is a bona fide member of a my lord Stadium View Cooperative Society. In our society, she also a member. My lord, she decide. বার করো, বার করো। ওর ডিমান্ডটা বের করো তো, কোন পেজ ছিল স্যারের দিক থেকে ফার্স্ট টাকার ডিমান্ডটা করলো, ওইগুলো ছাড়ো না, কোনো টাকার ডিমান্ডটা করো। She decided to Millard sold out his flat Millard to Millard third party Millard. Millard, what is the provision? So, তার কোন বইটা দেখা ছিল 31 টা
130. 131 3A.
ওইটা দাও।
3A.
বই আছে স্যার মাইলরের কাছে? মাইলরের কাছে বই আছে? আপনার ডবল কপি আছে তোমাদের? আমার রুলটা কোথায়? আমার একটা কোথায়? আমার একটা বইটা কোথায়? একটা দাও, একটা দাও। sale of his property, my lord, what is the duty? My lord, kindly consider. My lord, my lord, that's my lord, my lord. Before passing of the order, my lord, what has happened? My lord, the rules has to be, my lord, considered by the both the, my lord, authorities. My lord, if there is a violation for not following the rules, my lord, certainly, my lord, the petitioner has the right to assail before your lordship under 226, my lord. My lord, kindly see, my lord, 131, that is the Cooperative Societies Rule 2011. Here, my lord, kindly, my lord, yes, my lord, kindly comes to, my lord, 3A, my lord. Subsection, subrule 3A, my lord. For the transfer of land or house or apartment, a member shall obtain a written consent of the society, and before giving such consent, the society shall satisfy itself that it is transferred. I am not, my lord, traveling to your lordships on this point. My lord, first of all, my lord, the language has been used shall. Members shall obtain a written consent from the society before, my lord, entering into agreement to any third party, my lord. My lord, here in this case, my lord, without writing any letter to the society, my learned friend will not be able to show any scrap of papers that she made an application before the society. No, there is no question of cancelling, my lord. My lord, we have granted. We even, my lord, my lord,
Yeah, but assuming that consent is a very bad person, assuming he is not complying with regulations, bylaws, assuming that the person has not sought for your permission, saying that I have not given permission.
my lord, when this person my lord, first, my lord, no, there is a question of any bad good, my lord. My lord, what has happened, my lord? No, my lord, there is.
No, my lord, transfer.
No, my lord, in this case, what has happened, my lord, after, my lord, everything is complete. Even transfer was made, the registration was done. My lord, thereafter, my lord, no, it cannot said to be a bad transfer. Prior to that, my lord, we have issued a no objection certificate, my lord. That cannot said to be a bad transfer. But, my lord, she claimed rupees 5 lakhs after completion of all these things. My lord, what I am harping before your losses, my lord, she could have, my lord, raised this objection that we have demanded rupees 5 lakhs before issuing a no objection. My lord, we have not received any my lord, well, for development of the society, every member has donated, my lord. Yes, she donated. My lord, kindly, my lord, no, the document does not speak about that, my lord. That is why I am harping before. Lord. My lord, only two things I can show to your lordship that this rule has not been followed. 131 has to be followed, and my lord, 138 of the Cooperative Society's rules has not been followed. And all these, my lord, things has not been discussed even, my lord, although, my lord, this point has been raised before the, my lord, tribunal, my lord. And, my lord, if your lordship kindly take explain to the, my lord, opposition. My lord, 131, 3, subrule, subrule 3A of the rule 131, rule 138, in all cases, 138 says, in all cases of transfer and letting out of land, house or apartment, written consent of the society shall be required. A member of a housing society in whose favor a plot of land or a house or apartment in multi-story building has been allotted may transfer by of a sale as defined in the such and such, my lord. But this portion is not, my lord, relevant. Now, my lord, Roman 7, yes, my lord, where a housing cooperative society refuses or fails to give the written consent under clause 6, and if the member intends to prefer an appeal to the register against such refusal by or failure of the cooperative society, My lord, this will come when, my lord, the society don't, my lord, give any no objection. My lord, what is the reason of the private respondent to prefer an application before under 102, my lord? It is not the case. We have refused to give any NOC. It is not the case that prior to, my lord, the registrations, the society has already given no objection to the member. Yes. Yes, my lord. First, my lord, if, my lord, no member can get a no objection certificate from the society, he has to approach before the registrar for not getting NOC. That is the, my lord, that is the rule says. Therefore, my lord, when a person already received a no objection certificate, so therefore, my lord, 102, my lord, here, my lord, there is no question of, my lord, 102. And when such application was filed, after registration and all these things, almost after 5 months, 2 years, after 2 years, after 2 years of transfer, the limitation has not been prescribed.
3 years.
Well, for filing a suit, 3 years, my lord. And, my lord, the amount which they have, my lord, the private respondent tribunal award, my lord, kindly comes to page 167. The relevant portion is, my lord, 168. Order dated, my lord, 15/5/2023. ওইটাই হচ্ছে। না, ওটা না, তারপরে sorry. That's true, my lord. That is, my lord, that is, my lord, what has happened, my lord, I say to your lordship, my lord. But for reaction, my lord, 131 and 138, the power has been given in the society. It is for the development of the, my lord, lift. Yes, page 50, my lord, kindly comes to page 50. My lord, everything is there, my lord. It is not that, and showing the lift, my lord, he has charged more than 10 lakhs, the property which she has sold. My lord, it has been decided, my lord, kindly comes to page. My lord, kindly comes to page 50, my lord. For my lord, third floor, 35% charge. For second floor, 25%, and for first floor, 5%.
35 lakhs. In total,
And
13 lakhs for one lift.
For one lift,
13
total, my lord, 13 lakhs. For one lift, 30. No. For one lift, 13 lakhs.
Right.
Person 5 lakhs.
Sir, total 13 lakhs.
12.
No. 12 buildings. 12 buildings. And
দাঁড়ান না, একটু চুপ করে যান না, একটু আস্তে স্লো।
12 buildings.
No, it has been. It is the decision of the society. All members decided that for the ground floor member they will not charge. Yes, that is the resolution. It is the unanimous resolution of the. My lord, it is of 13/12/2020. No, prior to that also this is going on since 2012. Finally, it, my lord, came to no objection granted on, my lord, 11/9/2021. And showing this, my lord, that lift will be, my lord, installed. My lord, she has charged 10 lakhs from that by a prospective buyers, my lord. No. My lord, she voluntarily said since I will get more than 10 lakhs, no objection is that page, my lord, page 51. No, 51, no, no due certificate, no.
See page 54.
My 54. No dues is a 51, and my lord, the NOC is, my lord, 54. 54 হবে না। Just a minute. এখানে flagging-টা খুলে গেছে। 84. Just prior to my lord, the affidavit post. 84. আচ্ছা, এখানে 11 নম্বর বলছো, কত বলছো 11 নম্বর? Therefore, you are saying all these things. আমার ছেড়ে আমি বেরিয়ে 56, my lord. 56 is the resolution, my lord.
56. 56.
Middle one, my lord. Must. 317, yes. That Mr. Ratnabangji was informed that she has not yet communicated through any letter to the society, informing that she has taken steps in selling her flat such and such to her prospective buyers, duly vacating her said flat, explaining the reason for the same, and also has not asked for any no objection certificate from the society in writing, which is required as per Rule 147 of the amended West Bengal Societies Rules 2001. Mrs. Bagchi thereafter issued a handwritten letter prepared on the spot and signed by herself, detailing the check dated 11/9/2021 for rupees 5 lakhs, which has actually been voluntarily paid by her prospective buyers through her account for installation of lift and repair of her said flat number such and such, and formally asked for the no objection certificate from the society for selling her above flat to her above the prospective buyers. My lord. Yes. No. My lord. She is member at that point of time. No, there is no question of any circulation. The open board is there, and at that point of time, she was the member of the society. My kindly come. My lord, kind. লিফটের জন্য যেটা আমরা রিসিভ করেছিলাম সেটা রেজলিউশন আছে না, এরকম তো রেজলিউশন Milord, just beside Milord, the stadium, Salt Lake Stadium, the old society, very old society. 72 lakhs is too much price, and well, no, Milord, that is not, Milord, that is not the fact also, Milord. Milord, by showing lift and all this development, no, we are not opposing on that, Milord. Kindly see, Milord, Milord, my lord has to Milord, see the conduct of that lady, Milord. Milord, after 2 years, Milord, she could have been raised this dispute before the society, Milord. She could have been raised. And Milord, kindly comes to page 50, Milord. This is the resolution of the society. 55. 12% is there in terms of the award. Society is not so, Milord. Well, why it will be secured, my lord? Yes, that is the law. My lord, if my my lord, if we lost in this application, my lord, yes. My lord, for money degree it is required, but it is true, my lord. But previous orders, my lord, interim order, record of the case has not been produced by my learned friend, though there was a direction by the my lord, in earlier order, my lord. No, register has been directed, my lord. Perhaps, my lord. Yes. এই ওইটা দেখাতে বলতো যেটা ওদের স্যার ওইটা বার করুন তো ওদের যেটা রিটেন স্টেটমেন্টটা দেখান তো স্যার, কি জানো না যেটা দান করছি না আমার তো দেখাচ্ছি না কি বলছে শুনছেন 5 লাখ টাকা সিকিউর 5 লাখ টাকা সিকিউর রেজিস্টার লেখা আছে তারপর তো হিয়ারিং এ রাখবে কপি
I will have to take.
হ্যাঁ যেগুলো বললেন না ওটা accept করেছে।
শর্ট নোটস বলছি
কি বলছে
এটা সেক্রেটারি নিজে লিখেছি এটা এমবেডেড
After execution.
they have not filed any execution ফাইল করেছে No, that I have to take instruction the money well, kindly give me a minute 1 day time minute so that minute huh?
embedded
And minute
There is no dispute on that. Settlement is optional to make us. That voice says we are on that. As a state cannot want respondent join us feedback and we can additional charge. Who stops you? That only is there. How many years?
3 years
yeah over time is over
Ipsum মধ্যে ডিপোজিট করো রেজিস্টার জেনারেল বাইশে মামলা হয়ে গেল কি করতে গিয়ে বাইশে সার্কুলারটা দিন তো একবার বন্ধুকে দিন না একবার সার্কুলার দিল না মানে ওটা দিন একবার আমিও চোখ কাটি নিচে নামিয়ে দেবো। Yes. Well,
Stand outside and say, "Our order is that." He has to be well within the way. Like the way outside the because he means it is.
everything is against me. Everything is against me.
Not the amount of the first paragraph.
Everything is against me. ওইটা ওই জায়গাটা তুই বার করেছিস ডোয়া No, ultimate is a society, my lord. Even if we lost this writ petition without securing the money before the Registrar General, my lord, we have to, my lord. No, my lord. Society is not.
My lord,
No, she has given it voluntarily, but we have to pay it through, my lord, litigation, my lord.
I am paying only not to the one. Madam, Rita Batra appearing for the petition, madam, her mother is ill, madam. Therefore, only not to do. But I am appearing on behalf of respondent number 5.
Dhiman Kumar Sengupta is appearing for the petitioner, my lord.
Respondent number 6, my lord.
Attend due to some difficulty. My lord, Mr. Dhiman Kumar Sengupta is appearing for the petitioner in this matter. He's has some personal difficulties, my lord. I'm praying for not today. The monthly list of May.
I am appearing for the petitioner, your lordship, filing my affidavit of service. Well, there is a statutory violation of Rule 106.12
By Mr. Dhiman Kumar Sen.
of Rule 106.12F of Cooperative Society Rules. We have preferred we had preferred a writ petition previously. I have attached the order and I am for the petitioner. Well, they have not received their earned credit encashment that they were supposed to get. It was previously up to 180 days. Now it is up to 300 days. The cooperative society in their resolution, they have admitted that they should have enhanced, but they have not given. We have approached the registry. We have approached the registry. Page number 25, annexure P5. The copy of the resolution is on page 22, Your Lordship. Well, this is not a dispute, Your Lordship. This is a statutory violation for which we are coming before Your Lordship. Well, but they have admitted in their resolution that because there was not a resolution. Well, as per the order passed by the bench, we have approached the registrar. Yes, Your Lordship. Yes, Your Lordship. But yes. But my lord can get into this because my lord, this is not a dispute, Your Lordship. Because there was an order passed by Honorable Justice Amrita Sinha asking us to approach the Assistant Registrar of Cooperative Societies.
For the But, before going into the detailed merit of the writ petition, my lord, I'll say, my lord, this should be the fit case where petitioner ought to have been preferred a dispute case. What happened in this matter? A recruitment process was initiated. Now, my lord, it's terminated into my written examination. Interview was called on. Subsequently, lordship, the interview was postponed. No steps thereafter taken. That is the lordship the grievance. Now, my lord, I find from the writ petition there is no specific representation before the assistant solicitor. My lord, can you allow me to file a representation before them?
Your Lordship, may I say one thing?
Without my lord, dismissing the same, can you grant me liberty?
Recruiting authority is not a state article under Article 12, Your Lordship. It's a cooperative society.
Well, instead of that, like, can you grant me liberty so that I can move before that time, before the assistant registrar of property?
If no liberty is
But-
required, Your Lordship, if you wish.
Instead of dismissal, the same.
In this current lordship, I am for the petitioner, my lord. The petitioner is seeking fresh new election, my lord. Otherwise, election has been already expired, my lord. So kindly consider lordship annexure 3, my lord. P3, page 18, my lord. Praying, my lord, for new selection, my lord. New election may be held, my lord, as per the law, my lord. Artswell election has been already, my lord, expired, my lord, in the year of 2018.
Election is completed, Lordship, by 30th January 2025. It has become infructuous. Election declared, it's continuous process, everybody participated, election. My lord, only, my lord. This is, my lord.
Late by Mr. Rajesh.
Yeah. Well, in this matter, Your Lordship, there is a statutory violation. The petitioner, Your Lordship, has retired on 2018, Your Lordship, but still he has not got his retirement benefits. We have, in violation of payment and gratuity act, Your Lordship. We have preferred a writ petition previously, Your Lordship, whereas Honorable Justice Amrita Sinha,
Australian award was passed on of August 2024, Your Worship. An award has been passed by the Deputy Registrar of Cooperative Societies. So this is the cooperative societies who is holding back the.
is government.
I am for the Deputy Registrar of Cooperative.
My lord, it has. My lord, subject to correction, Your Lordship, gratuity has been paid till 3,50,000. After the enhancement in payment in gratuity act, the enhanced gratuity has not been paid, Your Lordship. My lord, 90. The appointment letter is, Your Lordship, 8881.
That's
28. My lord, the last drawn was on page 28, Your Lordship. Basic pay is 19,640, grade pay is 3,900, and DA is 23,541, Your Lordship. Nine lakh 77,836, Your Lordship. But after the so we will be getting 6,27,836 more.
Your Lordship, we have already indicated in our award that the enhancement was illegal without any board resolution.
Where is
Lordship, then in that case, Your Lordship, I am saying it on.
Yes, Your Lordship.
Lordship, that has to be supported by board resolution. It was not supported by board resolution when he was in charge of the society. He himself took this decision, Your Lordship.
Welcome.
Kindly adjourns this matter in that case.
My lord, they have taken a resolution to that case.
Your Lordship, I will consider and come back. Consider and come back.
My lord, affidavit of service. I am filing affidavit of service. 6,27,836. This is a deficit, Your Lordship. 836.
Yes.
Let me get it regularized. Okay.
Cooperative Department.
Department also.
Department of Cooperation.
With one of the juniors.
Grateful, Your Lordship. My lord, I am praying for not today, my lord.
It's on 29th of April. 29th of April. No, this one.
Lordship, in 1152, I am on behalf of the petitioner, Lordship. This is affidavit of service. Affidavit of service means Lordship, the crux of the grievance of the petitioner is that the wife of the petitioner took loan from Boidobati Shavrafuli Cooperative Bank Limited Service. And Lordship, after foreclosure of loan, the Boidobati the Shavrafuli Cooperative Bank Limited Society did not return the security document. Due to that reason, NSC, LIC, these are the security documents. Lordship, due to that reason, the wife of the petitioner was under compulsion to file a writ petition before this Honorable High Court. And Lordship, by strength of the order of the writ code, white page number 30, I humbly draw your Lordship's kind attention on page number 30. By strength of this order, the security documents were returned to my wife. Now, Lordship, my loan has been already foreclosed, but the banking authority has taken the same technique. Banking authority is not giving the security documents in my favor. Then again, I have filed this present writ petition. Lordship, wife's loan in the year of actually I have paid the entire amount. Same. In my wife's case, before 2023, Lordship. And my case also before 2023. Lordship, no, Lordship, I have given several representations, Lordship.
All matters, Your Lordship, this has to be decided under 102, Your Lordship, because this is a claim against the bank, Your Lordship. This is a or 24 matters, Your Lordship. There is a remedy under section 102, Your Lordship. He's saying that his loan has been paid off, but I have instruction. I am appealing for the bank, Your Lordship, for the cooperative bank, Your Lordship. I have instructions. No, Your Lordship, it has not been paid. Your Lordship, I am carrying two letters. One is addressed to Mita Sarkar, his wife, and one is addressed to Your Lordship. I have instructions that the amount of 7,510 is still due and payable, and in one 10 and the Your Lordship, the amount of security or the value of the security is I cannot. Lordship, and the other account is 1,86,000 is due. The Probit Chaudhary, this Probit Chaudhary. Lordship, kindly seize the, I am carrying these two letters. Kindly seize it.
Lordship, as per the instruction, Lordship, I am making my humble submission before your Lordship. From my end, no amount is due, Lordship. Page number 33, Lordship. As per this letter, Lordship, I have paid the amount. Mukund. $1,86,000 তো দেওয়া হয়নি তো। হ্যাঁ? কোথায় কিভাবে পে করেছে তার তো একটা রিসিপ্ট থাকবে তো।
The Lordship kindly allows him to approach the bank.
এই তো প্রবীর চৌধুরী। এটা তো প্রবীর চৌধুরীর লোন।
Page 33.
ওটা কে দেখুন ডেট ফ্যাব্রিকে ওটা কে তো প্রবীর চৌধুরীর তো। Lordship, one thing is that, Lordship, may I read this notice? It is Lordship, kindly come to page number 33, line number 4. Messrs. Debi Fabtech Private Limited. Now the question is that I'm asking myself, who is Messrs. Debi Fabtech Private Limited? It is not my company.
He stood as a guarantor in that loan account. Your Lordship, kindly seize
It is
the
not my company.
third line of the. Lordship, if a person is, Your Lordship, he has stood as a guarantor. Then Your Lordship,
Say that some other person has some other loan, bearing the guarantee, I will not because I will not be in this matter.
then in that case, Your Lordship, he should also not be a guarantor to someone if he is now not willing to take the responsibility, Your Lordship. Then this is a disputed question whether he was aware or not, Your Lordship. He is pleading that he is. Then Your Lordship allows me to file an affidavit. I will disclose as to whether he was aware or not. Your Lordship, that will do, Your Lordship. Kindly directs, I will file a detailed report.
Women. Well, but
Yes.
My lords, may I mention this writ petition of HON'BLE, which my lords have passed the order on 15th May 2024. This is a writ for refund, my lords. And it's been more than a year that my refund of 66 crores is pending with the department. So if my lords, this can be instructed to be listed.
it's ready, my lord. Filed also. Let it appear in the
Hearing matters, after I take up the motions, then only I can take up the hearing matters. You have to wait for a while.
I bow down to that, my lords, but it's only a matter of a large refund which is pending. It's a hardship on my treasury function, my lords.
Let us see what happens.
Kindly accommodate after vacation, my lords, if that.
I will certainly.
Grateful, my lords. Grateful, my lords.
You see.
Yes, I understand one. I understand one. Yes, I know. I've seen the list, my lord. There's so many. But if is conveniently fit.
It's a covered matter, my lords. Covered matter. It's grateful, my lords. Grateful.
Oh, would your lordship take the only fixed matter or other matters will be taken up?
No. Today, Mr. Sharma is here.
Yes.
So, see, Mr. Sharma's matter will get priority.
Yes.
And he's been waiting for quite a while on the sorry, Mr. Sharma, on the previous occasion, it was not fixed. So that is why I also did not know that I'll be there for a special bench. Otherwise, so therefore I could not accommodate you there. So I was not sure of the time also, then I would have intimated, but I sent the intimation. Yes. Yes. No, where are the other
side is there.
Other petitioner?
Should we wait or fix it?
Just let this matter be over. Not too much. Where is Mr. Sen?
My lord, I appear, my lord, virtually.
Yes.
Very good.
And yes. Long awaited affidavit on your part. Yeah, just show me that affidavit. Mr. Sharma, just wait. Let me go through the affidavit. Just 1 minute. I'll go through this affidavit. What is? Yes, you just indicate. Give him a copy. There is no difficulty.
We have not been received.
Give the petitioner a copy first also.
Received any copies.
What is your stand? First of all, I want to know in this with regard to the appellate forum. No, which paragraph? Which paragraph? Yes. That is very important. Contest the immunity. No, this is on merits. On maintainability, have you said anything? No. Which paragraph? First come to that and then show. Paragraph 17. Mr. Mukherjee, they have used an affidavit.
Yes, my lord.
Now I'm taking the affidavit on record because this affidavit I cannot, because this will throw light on various things.
Because I do not see any documents annexed to this
No, that is
affidavit.
different issue. That you got. If you want that, you can call for documents.
No, Manoj, I
No,
need to
go
study
through this.
this.
Mr. Sharma is here. I'll be hearing him today.
No, of course,
Yes,
but
yes.
I'll have to go through this. Manoj.
And so there is nothing on maintainability. Paragraph 17.
You need to understand the-
No, what is your stand? Is it premature? Or is it there is an appellate remedy? No, you cannot take that stand. And you tell me, he will not address the court. Please understand, is it your case? It is premature. If you say it is premature, then the final findings, after the final findings, the levy order becomes appealable. Then I'll construe as such, because this stand of yours will be in conflict with the stand of the central government in other matters. Mr. Mukherjee had relied on a particular affidavit. No, there cannot be no hide and seek before this court. You either come, be clean and say, what is your stand on this? So at this stage, it is premature. You're saying, so you withdraw it, you should not say it is premature. Now, how far a concession can be given by a council over an affidavit, that is a different issue altogether. Very well. No, I mean, let Mr. Sharma complete. Yes, Mr. Sharma. You have read it?
I just was going through it. Manoj.
Go through it. Yeah, no. I have accommodated you today, so I will hear you. So go through it. You let your junior go through it and let.
Yeah, I'll be as short as possible, Manoj.
আমার মনে হয় না লাগবে দেখার বিষয় এই কন্ডিশন গুলো চলছে ঘরে Yes.
Yes. But these Malods argue that the core of the matter is very short, Malods, and a very narrow one. And he says that whether the titanium dioxide, Malods, manufactured through the rutile sulfate process is manufactured by the domestic industry or not is the core issue that he is raised, Malods. Why does he raise this core issue, Malods? Because he says that if I do not manufacture, then from the PUC, this product can be ousted, Malods, excluded, and then there'll be no duty on the titanium dioxide.
Two parts, production and commercial sales.
Yes, of course.
He said also commercial.
Yes, production and commercial, no doubt about that. I will come to that. Now, Malods, he says why? Because my members have not sold you anything, or you have not purchased from my members. Therefore, probably it's a presumption you do not manufacture this, Malods. That's the core.
He has also indicated that was one part, and the second part that he indicated, apropos this, that there was no request by you to claim confidentiality in respect of the names.
That is the second leg of it.
Second leg.
I'll come
two things.
I'll come to that.
Yes, also.
But broadly, the petition, if I have read it correctly, Malods, is structured around this, Malods. And therefore, he says, kindly disclose the names. So he says, if you disclose the names, I'm happy and I'll go to school. That's his case. And why does he say that I need the names? Because he says, my right to appeal. So he doesn't dispute there is an appeal process which is available to him.
No, they admitted position,
Correct.
there is an appeal.
So he says, because you have not disclosed the names, my right to appeal is prejudiced. Core. Now, to understand this premise of his argument, my lords, we have to understand what was the PUC, my lords, and what is the importance of a PUC. Your lordship has
that you had argued that
yes,
you could not, one could not differentiate between that, and the PUC included everything.
Correct.
And it is the Titan I have recorded.
Yes, my lords. Now, my lords, what is very important is there is no dispute by them that the titanium dioxide manufactured or produced by the rutile sulfate process is a like article. So therefore, the moment it is there as a like article and there is a finding of fact today by the designated authority that it is a like article and it is interchangeable, my lords, everything else falls on the side. Well, whether I manufacture, and I said this before, I'm just summing that up, my lords. Whether I manufacture rutile process, sulfate process or not becomes irrelevant. And this argument, again, as I said, is on a demurrer. The first argument.
Today you have argued the matter by showing documents. You have relied on documents. You can't really say this is on demurrer.
No, even otherwise, my lord. Let us,
because
even otherwise, my lord, even otherwise.
You have relied on documents. You have shown.
Correct.
You have shown your letter.
Correct. My lords, there is no dispute.
So I cannot today say that I will only accept whatever is there. Because everyone has come up. His affidavit is also there.
Correct. Absolutely right. I'm so grateful. My lord, second point is, this is besides the fact that I need not show manufacture or I need not sell rutile sulfate. I actually manufacture, my lord. I demonstrated that. And my lord said, take it, the PSU, which is TTPL, Travancore Titanium Products Limited, Producers Limited.
Yes.
It's a PSU company based out of Kerala, owned by the Kerala government. Solely manufactures, and there is a finding to that effect. And
yes, I've seen that.
Your lordship has seen. Only manufactured through rutile sulfate process.
Very well.
There is a finding your lordship has seen that I have the production facility as well as sales as far as rutile sulfate process is concerned.
And who is expanding that? That is, they are also expanding. TTPL is expanding.
Yes.
That was the observation made.
Yes, that is the observation by the designated authority.
Yes.
Well, there is another company called Make Money, which is a domestic industry again, which is also coming in the fore. Now, may I say this, Malats? Why is the question of whether I manufacture this or not important, Malats? That is because under Rule 2B,
yes,
in order to be classified as a domestic industry, I have to show manufacture. If there is no manufacture of the product under PUC, my application for initiation becomes ineffective, my lords. Right? So therefore, secondly, my lords, in case a particular product, my lords, is shown to be different, not a like article, my lords, it does not have the characteristics of the PUC, then that product can be excluded. There is, in this case, neither of these two things are satisfied.
This you have already indicated.
Yes. Now,
very well.
Assuming, my lords, they are not happy or they are not satisfied with the final finding and the duty is imposed, the appellate remedy is available. They can always avail that appellate remedy, my lords. Now, my lords, coming to the next point, they say that the names are so important that because the names are not disclosed, my right to appeal has got prejudice.
They don't really say, they say that
They say so in the appeal,
they say
in the writ
for the
petition.
purpose of appeal, but they also say that in term there has been non-compliance of 7(2) of the rules as well.
Correct. That is a separate matter. Well, I'll come
That's
to that.
all interlinked.
That is
This is all
that
interlinked
is the
together.
confidentiality part of it, my lords.
But this is all interlinked
Yes,
together.
yes. But my lords, the question is, if there is no
If
prejudice
there is
to them,
confidentiality, then there is no question of disclosure.
but
Matter ends there.
correct, my lords, let's keep that aside for a moment. Now, let us understand, if they are not prejudiced at all by the non-disclosure, my lords, how is their right to appeal how is affected, my lords? And I have, my lords, asked my friends who have briefed me, my lords, I have tried to apply my mind. I have not understood till now, my lords, how because of the non-disclosure of the names, my lords, they are prejudiced from filing an appeal. All they have to say that XYZ company, they do not manufacture titanium dioxide. The appellate authority has the entire wherewithal, my lords, to call for the files, look into the documents, my lords. The writ court is not going to do that. So why not go there and tell the court, they do not manufacture? That remedy is always there. And their saying, my lords, can be immediately, my lords, corrected or remedied by a simple direction, my lords, that appellate tribunal, you decide this appeal within a period of 6 months, constitute a bench. That lordships under which jurisdiction has the power, my lords. Now, para 11 and 12. My learned friend wants me to read 2 paragraphs of this affidavit, my lords. The lordships will come to page 6. May I read para 3, my lords, quickly? That post initiation, yes, my lords, para 2, my lords, para 2, my apologies, my lords, page 4, the bottom portion of that, my lords. This is exactly what I argued just now. The information about 6 lines from the bottom, my lords, lordship says that the information required to be provided by the domestic industry in its application includes the information about production and sale of disputed grade, that is rutile grade produced through sulfate process by one of the petitioning companies, Travancore Titanium Products Limited. TTPL is the only applicant company who produced and sold titanium grade produced through sulfate process. Then, next paragraph, my lords. These documents were given at the initiation itself, my lords. Then, the domestic industry, page 5, my lords, claimed confidentiality. This is important. On the same in the application itself, with due cause, the domestic industry provided non-confidential copies of the petition to all interested parties. This is again another important thing, my lords. I have been saying that. While the Indian Paints Association filed comments on certain other confidential claims of the domestic industry, the confidential claims of the domestic industry on the above documents, as per the above table, was not disputed by the Indian Paint Association. Para 3. Post initiation, as a part of the verification conducted by the authority under Rule 8, the domestic industry provided a large number of documents on 9th August 2004, which included the following. Well, these are the sale invoices and Excel sheets, etc. In response to the verification queries from time to time, the company provided following documents and information on confidential basis. XYZ, Malad. These are the details. 5. That during the course of the anti-dumping investigation concerning import of titanium dioxide originating in or so and so from China, received multiple submissions and documents from various interested parties, including domestic industry importers so and so. These that many of these submissions have been claimed as confidential by the respective parties in accordance with Rule 7 under so and so. Next, the designated authority is duly examined, para 7, the claims of confidentiality made by respective interested parties and has treated such documents and information as per its merits. And I'll show that finding also.
No, that cannot be reopened again. These are all closed.
Yes. No.
They,
Finding
if
in the final
something is
finding.
not there, that cannot be improved by an affidavit.
Of course not. No, I'll show the finding, I say.
Finding is there already. Yes.
On the confidential part, that
Yes, that part.
Yes.
These paragraphs will not come in his aid.
Of course not. What is there on record, Lordship will
Correct.
go by that. But I'll show that finding. Lordship will quickly.
Because today, Mr. Sharma,
Yes.
the non-confidential summary of the confidential information in the same format I have read is not disclosed here. In the affidavit, it has not been disclosed that you have submitted that.
It's statement.
No,
Let me see.
show
It
me.
is written
Show
there.
me which paragraph.
I just read that.
Yes.
One second.
Show me which paragraph. That is at the time of initiation, Mr.
Yes,
Mr. Sharma.
Because these documents were given
Actually,
at the
but subsequently, you see, as per Rule 7, whatever you give, you have to give along with a non-confidential summary thereof. Whether you have given that,
yes,
it's
they
not
say
there
so.
here.
I just read that, I just.
Yes. But I'll tell you where you have read it.
Yes.
You have read it, Mr. Sharma, at page number 4. Starting with page number 4 and 5.
Yes.
4 and 5, it is there.
Yes,
But
yes, I'm so grateful.
Yes, that is there.
Page 5.
Immediately next page, you see, this is at the stage of initiation.
Correct.
Next page, Mr. Sharma comes to Rule 8.
Right, Rule 8.
So 7 is not there.
Rule 6. During the course of Rule 6.
Yeah, that is
course
page,
of Rule
page
6,
number 5.
verification. No, the initiation is under Rule 5 and the investigation.
I said page 5.
Yes,
Right.
page 5. Yes.
Rule 6, yes.
Rule
Thereafter,
6.
yes. Very well. Whatever is there is there. This cannot be improved or by this process, you cannot change it. So,
Let's kindly see page 9 what they say also.
Yes.
That's important, I think. The designated authority has issued trade notices from time to time, laying down guidelines for the parties for claiming confidentiality. If confidentiality has been claimed by parties consistent with trade notice, the designated authority allows the same and does not pass specific orders for each element of confidentiality claims made by each of the parties, particularly when a large number of interested parties participate in an investigation, and it is quite customary for such parties claim such information as confidential, which is routinely allowed by the authority. Since these claims were consistent with the rules, trade notices and guidelines being followed by the authority from time to time, the same were allowed.
Where is that line?
I'm reading para 9.
Yes,
I'm so sorry.
I just missed out. Yeah, I got it. Routinely allowed. Yes. Yes.
I was reading over the page, Malad.
Yes. Next.
Time to time, the same was allowed by the authority without any specific orders thereon on each of the elements of information by each of the party to the investigation. Annexures of trade notice number so-and-so provide guidelines on confidentiality of so-and-so. Correct. Then, Malad, para 10, since the authority is faced with a large number of investigations at any point of time, and have been conducting such investigations over 3 decades, it is evident that there are certain consistent practice that has been followed by the authority. This includes the consistent practice with regard to confidentiality claims allowed by the authority. The name of the customers or commercial invoices that are in the nature of information came by interested parties are as confidential and allowed by the authority.
Can the DA say this? Unless you are the domestic industry.
Correct.
Unless the domestic industry claims confidentiality, can the DA say
I have
this?
claimed.
Now that is a different issue.
Yes.
But they have said.
They have said so.
They are
Right
saying it is generally confidential. There cannot be, because you have shown me the judgment of Make Money. Make Money makes it very clear.
Absolutely.
The language is very clear there.
I am so grateful, Malad.
You cannot ask for, they cannot say that this is confidential unless you claim for it. And once you claim confidentiality, they cannot disclose it. It is for them either to reject it or to accept it. They cannot disclose it.
I'm so grateful for the question, Malad.
This is only here.
May I just enumerate on that. My lords.
No, we are on the affidavit only.
Correct. No, but let me clarify, because this is something very important that comes out of the question, my lord. I should explain that right away. There is no doubt that while giving this information at the verification process also, I claim confidentiality.
Yes,
Inherently,
correct.
my
No
lord,
doubt about it.
inherently, there are two types of documents that are confidential. One, which are by their very nature confidential in terms of business workings, etc. For example, invoices, the price at which I sell to a customer, etc. These are inherently confidential.
If you consider it confidential.
Yes, I did. I have said so in my affidavit, in my this arguments also. They
Letter
have said
is
so
that
here.
letter.
Not that letter. That letter is much later. In the verification process also, when I give them the documents, I say it is confidential. I think the officer has the file. Your lordships will verify those files. I have no difficulty. I have claimed so, my lord. And I have strict instructions to say this, my lord. I have claimed so. Right at the threshold, at the initiation stage, I have claimed. At the verification stage, I have claimed. Those letters will be there, my lord.
The records have come.
Yes, all records are there, my lord.
Very well. Records are here.
एक मिनट बात कर.
Okay, very well.
अरे पहले ये खत्म. Malad, may I continue with this?
Yes.
And there are documents that are claimed to be confidential, which are by nature not confidential. My respectful submission is Make Money and Rule 7 deals with only such documents. Documents which are inherently confidential are always confidential. Now, Malad, just assume a scenario. There are 30,000 documents that are received by them. Now, if the designator, and that is exactly what they say, for each document, they are to give a finding. They will.
No, correctly said.
Exactly.
So that on
I'm
that,
so grateful.
it cannot be that you see on each and every turn and no, you have to record this has happened. It is not possible.
Correct.
Because you are after continuing adjudication process.
Correct.
So there may be slips here and there also. But that
Absolutely.
does not necessarily mean. Question is whether the broader principles has been complied with or not.
Very much so.
That is the most important part.
So, the documents which I claimed confidentiality as such, Malads, those were the documents regarding volume and price. Lordship has seen the specific finding in the final finding where the price has been kept confidential, but the volumes have been disclosed. So
Very well. This is all there.
Yes.
I get it. This
Yes.
is all he goes on paragraph 13. He has said that you have claimed confidentiality on everything.
Correct. Malads, may kindly see this is confidentiality and perusal of the contents of the email and its attachment. The authority was of the considered view that invoices by the very, this is exactly the point I was making, para 12, Malads. Lordship sees para 12. May I just read that? Upon perusal of the contents of the email and its attachment, the authority was of the considered view that the invoices by their very nature constitute confidential business sensitive documents and which are already on record of the authority, for which confidentiality has already been accorded at the time of initial application. Lordships will underline this. I had not read this earlier. Moreover, the invoices submitted by the domestic industry were expressly claimed as confidential and has been treated accordingly throughout the course of the invest. This is the answer. It is also pertinent to note that all other interested parties similarly claimed confidentiality over their respective invoice details, citing the commercially sensitive nature of such information. All such documents form part of the official record maintained by the answering respondent. Malads, I have with me.
He has not disclosed this to petitioner. That means that he has claimed confidential.
Correct. Number one.
Without that, he could not have held back it.
Correct. Interesting.
I accept that position.
Interestingly, Malads.
Paragraph 13, that clarification is also there.
Yes. I'm so grateful.
Very clearly it's there. So that does not require special mention today.
Correct.
Question is not of anyone else. Question is the statement is whether you had claimed. He said you have claimed confidentiality. Fair enough.
They said so, Malad. They
Fair
said
enough.
so on affidavit, Malad. Number one. Number two, it is not as though the designated authority has acted in an arbitrary manner by keeping my invoices from them and not giving their invoices. The same, Malad, when their invoices were given to me as a part of their disclosure, that portion of their names of their customers were retracted, Malad. That was not given to me. That was kept confidential by them. So the same treatment has been given to both the parties. That's my respectful submission.
Very good.
Well, two findings of as far as confidentiality that my learned friend wants me to see. ज़्यादा नहीं है, time नहीं है बस. Correct. Lordship will see 312 for a moment. My learned friend wants me to show this.
Yes.
The last paragraph of that. DD. Small dd malats. The authority made available the non-confidential version of the evidence presented by various interested parties on mutual basis in the manner prescribed in trade notice so and so. The information submissions provided by the interested party on a confidential basis were examined concerning the sufficiency of such confidential claims. The authority has considered all the arguments raised and the information provided by all the interested parties to the extent that the same are supported with evidence and considered relevant to the present investigation. Correct. Well, BB and CC also, the information submitted by the domestic industry has been examined and verified during on-site verification to the extent deemed necessary and has been relied upon for the present.
BB and CC is there.
Yes.
Only DD is not there, missing in the affidavit. It is there in the order.
Yes, yes. It is there in the order also, Malad.
But there is no dispute. One factual aspect should be clarified.
Yes.
You have either considered, they have disclosed. But there has been no disclosure of the summary of the confidential information in non-confidential form.
Malad, that.
No, factually, sir, I need to know the fact. Otherwise, I will go wrong on facts.
Absolutely, absolutely.
So that was not done.
Malad, my respectful submission to that is that was not required because everything in that invoice.
Very well. That not done as it is not required.
Why? Why? I'll tell you why.
Yes.
Because everything in that invoice is confidential. Because how can I give us non-confidential summary?
I am only on whatever is written there in the statute.
No. Malad, it is
language of the statute is that.
Correct.
So that according to you, that was not done because it was not required. Because everything was confidential.
I'm so great. I'm so great.
Everything was confidential.
And your lordships will see at page 223, 323, my lords, he deals with these documents also. Sample, domestic, and I'll just read it out, my lords.
Yeah, just a minute. I'll just record this. Because after all, if I go wrong on facts,
yes,
because tomorrow it is said that you provided the summary,
correct,
then it will be.
If your lordship is recording, I'll take instruction. Yes, no, not only provided, but these are confidential and the information is not required enough non-confidential.
Not in, yes. You provided the information and said everything is confidential. Correct. And therefore non-confidential, the summary of the confidential information in non-confidential form was not provided.
It's not the question
because
of
not required in this case.
Correct. Because everything in that invoice is
your explanation is there. I will record, but the facts I have to record.
Yes. Correct. Well, I have to add that all confidential information in a non-confidential version, as far as the injury is concerned,
was provided.
Yes.
That is there in the affidavit. I've seen that.
Yes.
This is the second part with regard to page 6 and onwards.
This is the niche fact, Malad.
Whatever is there, facts.
Yes, of course, Malad. Your lordship is absolutely right.
That is all.
Last thing, Malad. 323.
And one other thing, you can also answer. First of all, you complete, then I'll.
323.
Yes, on factual, very well. 320. 323.
Yes. Sample domestic Roman small Roman 5 at the top of internal page 70, 323. Before examination by authority, my lords.
Yes, yes.
Sample domestic and exports sales documents have not been disclosed. While documents may itself be confidential, the list of documents submitted has not been disclosed, my lord. And then lordships will see page 324, the last sentence, 324. Para 23, the last sentence there. The authority also notes that all interests.
Just a minute.
Yes, I'm so great.
324. The last sentence of the paragraph 23.
23. Lordship has
Authority
underlined
also
that.
notes that all interests by have claimed business related sense. Yes, yes.
Yes, Lordship has
It is already marked.
That is all. And I'm happy to answer any questions
Yes,
coming
yes.
from.
Now, Mr. Mukherjee on the last occasion had, no, not you, Mr. Mukherjee, senior Mr. Mukherjee on the last occasion had taken me through the provisions of the Act as also the citing of Mr. Mukherjee. As also the GATT agreement 1994, because this forms the basis for this particular statute.
Statute and the rules.
He has placed reliance on 6.9, 13.1 and says that basis must be disclosed. In an adjudication process, ordinarily, the reasons and the disclosure ordinarily has to be there. Without a reason, in an adjudication process, it will be very difficult for the appellate authority to consider what has happened. Similarly, reasons must be supported by basis, and basis should be disclosed, at least broadly. Considering the nature of the Act and to protect, certain checks and balances have been provided. And having regard thereto, certain restrictions are there. But to what extent such restrictions will be there? Will it be to such an extent so as to not permit the adversary to know what was the basis? This was one of the issues that was highlighted by Mr. Mukherjee. More or less, you have answered.
Yes, Malad. That is exactly what I was going to say.
More or less, you have answered this. Your explanation today covers it all. The other aspect that Mr. Mukherjee highlighted was that there has been an amendment. And he had explained why it is not notified. And he has explained that that is why I wanted to take the stand of the central government. That today an appeal from a final order, not that this stage under Rule 18, is not maintainable before the appellate authority.
I'll answer.
Do you have anything to add to that only?
Yes,
because the state has really did not answer this.
Correct. I will, Malad, answer both. I have answered the first question.
That part is over.
Just to reiterate, Malad.
No, not necessary. That part is over.
That part is over. I have answered.
No, these 2 points are taken. So
yes, yes, of course, Malad. I am aware of that. But I thought the second part of it, as far as the proceedings here are concerned, was not relevant, Malad. And therefore, I thought in view of the time constraint to ignore that.
No, just give me an overview.
I
Just because not necessary.
I'm so
you don't need to take me through the entire
provisions and all, Malad. I'll make it very simple, Malad. Now,
before the amendment and all the judgments are prior to that.
I will tell your lordships what was the words before the amendment, order of determination.
Correct.
And after the 2003 Finance Act, it is
The determination.
determination. Lordship has gone through the rules. What was the process earlier, my lords? The final finding of the designated authority today, that is after the amendment and before the amendment, is always the determination. Is there a change in the way the government has perceived it, my lords? The answer is the same. It was a determination earlier. Today also it is a determination. Now, earlier the government thought that that order, that determination was actually an order. So, my respectful submission would be, my lords, that the exclusion of the words is a legislative correction, because they feel today that the order, the determination is not an order, because Reliance, what does Reliance say? Reliance says that the recommendation is only a report. And throughout the judgments and throughout everything, my lords, everybody has said that it is a recommendation.
Yes.
Had it not been a recommendation and the legislature, by removal of these words, order of, wanted to make the final finding the actual impugned order as such, then the word may, which your lordship sees in 18, would have also been removed. That discretion to the central government would not have been there. So why do we say it is only a report? It is an assistant report of an assisting the central government to come to a finding as far as Rule 18 is concerned. That is because, my lords, the word may. Today, the report or this finding as it is, my lords, is a piece of paper. The central government might very well not impose. Then all these proceedings, my lords, or any appellate proceeding against that is a completely, my lords,
That Mr.
futile
Mitra has
exercise.
argued on recommendation, everything.
Correct.
That is all?
That is all. I'm so grateful, my lords.
Yes, you
It's
want
been a
to,
pleasure.
just because.
Lordship has taken out so much of time. I've seen
No,
Lordship's
I need to
roster
complete
is
this,
such a heavy
because
roster.
unless I complete this matter,
Yes,
because
of
the
course.
matter has to be completed.
Of course.
And I have heard this matter.
Yes,
So I need
I'm
to
so
decide
grateful, my
this.
lord. It's been a
Whichever way it goes, that is.
It's been a pleasure.
Yes.
My learned senior is appearing virtually, Pullets. So,
May it please your lordship, my lord.
Yes, Mr. Mukherjee.
Yes, my lord, I have got the affidavit now. My lord, let me, my lord, just verify, my lord, that and kindly keep it anytime next week, my lord. I'll take 10 minutes.
Very well. And Mr. So far as your stand is concerned, you say that you have taken a contradicting stand. You say it is premature, and you say there is an appellate forum. Then you do not.
On the paragraph 7.
Yes.
I mistakenly spoke in this manner, not wrongly.
So you want to withdraw that?
No,
Then you have to file another affidavit. Then you have to file another affidavit. Please understand. Please understand that your affidavit is now in conflict with the previous affidavit. Very well, whatever you wish to. Only this, Mr. Mukherjee, I am
Yes.
in the matter. Usually, I don't know when the other matter would be there. So I'm keeping this matter. If there is any difficulty, then on that particular date, it may not be taken up.
Very well, my lord, whatever.
No, generally, if I'm sitting in a division bench, that is the reason why. So that's
No, that's, my lord, I'm fully understandable, my lord. That's no problem.
Very well. Affidavit in opposition filed on behalf of the respondent number 1 is taken on record. Mr. Sharma, learned senior advocate, representing the respondent number 3. No,
I represent 4.
Respondent number 4. Full stop. List this matter for further consideration under the same heading next Tuesday. No, you tell me, you will answer.
My lord, could it be Wednesday, my lord? Wednesday?
I'm keeping it on Wednesday, but
No, that is, my lord, we'll take our chance, but I don't
Yes,
I
yes. Very well. Wednesday at 3:15. 3:30 you come, I'll keep it 3:15, 3:30.
Grateful.
And the disclosure that you have made here, in addition thereto, there is no other documents. Because the previous two documents that you have disclosed do not form part of this. So I will ignore those two documents. On the next occasion, it is there. No, that is never recorded.
I know. But since the request is
No, that is never recorded.
Morning ban today.
Your presence is recorded.
your lordship. So
Morning, sir.
Your presence is recorded. There is no scope to record any other. Wednesday week.
I learned something very interesting today, Malad, just on the lighter side. I saw lordships wearing this band, and I was
Weepers.
asking my learned friend because I've never seen this ever.
These are weepers.
So only in
Yes.
Calcutta High Court probably has maintained the tradition.
No,
No, my lord,
courts also, but Mr. Mukherjee would be in a position to confirm.
The band
Other
also, I'm told it is a striped band, which something
today,
again for the
state
morning.
mourning has been
Yes,
declared.
Yes, I believe so.
So that's the reason.
I think, I'll take back something today, Malad, from here.
my lord, most chartered high courts have this, my lord.
Yes.
Delhi, of course, was a circuit bench, my lord, of the Punjab and Haryana High Court. So, my lord, I don't.
Bombay and Calcutta, Bombay and Chennai also, but never something very interesting.
These are weepers, and this is the mourning band because the state mourning has been declared. You see, all the advocates will be wearing the mourning band.
And I saw Justice Dipankar Datta, when
Yes.
he's the chief. So for the ceremonial, whenever there is a oath taking,
Yes.
he would wear a very long kind of a gown, I mean coat.
Yes.
So these are called the ceremonial coats, I was told by him.
Yes.
Very interesting.
Then Delhi, it's also there.
Not there, but I haven't seen it in Delhi at least. All of this doesn't. Delhi is very.
The tail coats.
My lord, may I indicate my learned friend would have surely seen, my lord, Mr. Chadda, senior advocate of Delhi High Court. He only wears tailcoats in winter.
That is only one. He every day.
Because, my lord, learned judges wear those, and my lord, senior advocates. And Mr. Amit Chadda, my lord, who is a senior advocate, is always, my lord, in a tailcoat in winter.
Oh, very well.
My lord, I'm telling Mr. Sharma about his own high court.
I haven't seen my learned friend has traveled so much in his initial years. The experience that he's had.
Yes, certainly.
Just phenomenal.
Tons behind him.
Yes, it can't be. Great.
Your lordship, they do not need to present an order with the documents because they are carrying the documents.
I don't know.
My lord, they should be there, my lord.
Yes, let them be there on the next occasion.
Your lordship. Wednesday week.
Is he carrying all the records? Then I will record that he has. So it can't say that. I can't say that. He maybe relevant documents is available with him. I don't know. Because if you say, it is for you. I'm not asking him. It is for you to say. If you say all the records are available, then I will record it.
Yes, related to the affidavit. Your lordship.
Yes. Very well. Let him come on the next occasion as well. Yes. আর কি হবে এখন দেখে তুমি মেনশন আছে দেখে দাও yes
Obliged, your lordship.
yes
Grateful.
Lordship, this petition was filed for restoration of GST registration. Lordship, after filing the registration petition, the GST registration has been restored. I will seek leave to.
file দাও No. the learned advocate representing the, yes, Mr. Yes, yes.
In this matter, to cut it short, appellate authority ordered that to restore back his registration. It was
That's it.
done.
So I'll record. He does not want to press it. I'll
Ah,
record
yeah,
it's been restored. No details are necessary, sir. Appellate authority orders restoration.
Yes, Your
Yes,
Worship. Page.
Page number 45. Lordship, page number 41 to 45.
Then why did you file the writ petition?
His allegation was that despite appellate authority's order, they were not restoring.
The present writ petition had been filed inter alia seeking implementation of the order passed by the appellate authority under section 107 of the WBGST/CGST Act 2017 Yes, yes, only this is the last matter. Delay of 110 days.
Due to my illness, I was unable
Your
to.
illness. Your illness.
Yes, my.
Then you can't oppose. The instant, instant application has been filed.
In the application, once it is
Don't,
referred
don't
as-
oppose. He says his personal illness in that.
No, no, I am not opposing the limitation. On the petition, in the petition, once it is referred to as appeal, once referred to as suit, and
Because he's saying he's ill, then I will not. I'll allow that. Was there any interim order? I will not restore the interim order.
No. Kindly look into the page 8, my lord.
Very well. Having heard the learned advocates appearing for the
Yes. Grateful and much obliged, my lord. No, this is in the May